Turning then more specifically to the question of the court's jurisdiction ratione temporis. On Monday, I discussed how the only sensible interpretation of Article 22 is that it should be temporally limited to acts and facts that occurred at a time when the parties to a dispute are both parties to a convention. In other words, when the convention is in force between them. To find otherwise risks creating serious irregularities that the drafters of the cert cannot have intended. Could the drafters really have intended that states that only later accepted their obligations under the convention should somehow acquire a procedural advantage over states that accepted those same obligations at an earlier moment in time? Professor Lowe notably had nothing to say about the absurdity of such an approach. As we also explained on Monday, allowing Azerbaijan to raise claims relating to the pre-96 period would raise serious retroactivity issues. Yesterday, Professor Lowe responded confidently that, quote, there is no question of retroactivity in the present case because the relevant conduct underpinning Azerbaijan's claims of breach occurred after CERD's entry into force for Armenia in 1993. With respect, this misconstrues the nature of the problem. This is not the retroactivity issue we are talking about. The retroactivity issue here is that Azerbaijan is trying to use Article 22 to reach back in time and claim the right to raise questions about Armenia's compliance with its obligations under the CERD in relation to a period of time when Armenia did not owe those obligations to Azerbaijan.